Hello, scholars. This is Mr. Myers. We're going to talk about Lesson 3.3, the Justice Process, Dealing with Trials. Our objectives for today are to talk about interrogation standards and important Supreme Court cases related to that, booking and initial appearance, the bail and pretrial release process, preliminary hearings in the grand jury, felony arraignment and plea bargaining, and then last, the difference between jury and bench trials. Okay, let's jump in. So in the last lesson, we talked a little bit about searches and seizures, when the police can stop you and when they can arrest you. In this lesson, we're going to talk a little bit about what happens next. So first, let's talk about interrogations and confessions. A couple Supreme Court cases we definitely need to be familiar with. The first is Miranda v. Arizona from 1966. And basically, this Supreme Court decision said that the police must inform suspects of rights to counsel and to remain silent prior to questioning. Most of you have probably heard that you have the right to remain silent. Anything you say can and will be used against you in a court of law. That came out of this particular Supreme Court case. In addition, another Supreme Court case that deals with the rights of the accused is Gideon v. Wainwright from 1963. While the Bill of Rights does indicate that people are allowed a lawyer, it doesn't say anything about providing one for people who are indigent, who are poor, and can't afford one. Now, this doesn't mean that you have the right to a state-appointed lawyer for, say, traffic tickets, but if you are being charged with a crime, you do have the right to an attorney, according to Gideon v. Wainwright. Lastly, let's talk about interrogation standards on this slide. The police cannot use physical or psychological intimidation. They can't say, if you don't tell us what we want to hear, you're going to go to jail and horrible bad things are going to happen to you in there. But they can lie to you, and they can lie to you blatantly and do all the time. If you ever find yourself in a position where the police are talking to you and you even remotely think that you might be a suspect, you need to close your mouth and ask for a lawyer and not say anything. So after an arrest has been made, the next step is going to be booking. And this refers to the police recording the suspect's name, taking mugshots, fingerprints, collecting DNA samples, conducting searches of the individual to make sure that there's no weapons or anything of that nature, and then any property that they have would be taken into custody and recorded. Now, there needs to be an initial appearance in the court within 24 to 48 hours of an arrest. For misdemeanors, the suspect would be immediately arraigned. Basically means that they would be formally charged right away, and the suspect would then enter a plea. For felonies, which usually involve prison sentences of a year or more, the suspect would have a bail hearing at the initial appearance to determine whether or not they would be released before the trial, and if so, how much money they would have to pay in order to get out. A pretty famous booking recently happened in the summer of 2023. Donald Trump was indicted on charges of mishandling classified documents. He did have to appear in front of a judge, enter a plea. He was fingerprinted, although they did not take a mugshot of Donald Trump because they said he was so famous that he didn't need one. So if you've been charged with a felony, and in the case of some misdemeanors, you will have the opportunity to possibly post bail and be released before your trial. Bail refers to money that is put up in order to guarantee that you show back up when your trial actually starts. Bonding companies are companies that ultimately help provide that money to people who can't afford it. Bail schedules are set in advance for a lot of crimes, so the amount of money that would be required for a release in many ways is kind of already predetermined. The judges can deny bail for the severity of the crime or if they feel like the defendant might possibly be a flight risk and leave. Suspects can post 10% of the bail and then use a bond company to pay the rest of that bail. And then, of course, they would have to pay the bond company back along with a fee for that service. And sometimes the judge can release a suspect on their own personal recognizance. Sometimes this is done if the defendant is particularly famous. That's what happened recently in the indictment with Donald Trump. Now, in the case of a felony, it's likely that the suspect will get a grand jury hearing. And basically what that refers to is the evidence being presented in front of a grand jury made up of civilians like you and I. And that grand jury would simply determine whether or not there was enough evidence to move forward with a trial. And the basic idea here is that you wouldn't want to charge someone with a crime willy-nilly, that, charging someone with the crime of murder with very scant evidence could greatly damage someone's reputation. So to protect that, to have an extra layer of scrutiny, we have the grand jury process. An individual can waive their right to a grand jury and have a preliminary hearing, and basically that the judge then would determine whether or not there's enough evidence to move forward with trial. So let's talk about the felony arraignment. If you were charged with a misdemeanor, you probably would have had the arraignment at the initial hearing. But in a case of a felony, the arraignment is the formal charging in court, and that happens after the grand jury or the preliminary hearing agrees that there's enough evidence to move forward with the trial. At this point, pretrial motions would happen, and this is when the lawyers would haggle about what evidence could be admitted or not be admitted, or this might be an opportunity for you to bring up the fact that your confession was coerced by the police, or whatever the case might be. And then, of course, you would be entering a plea. You could enter a plea of guilty or not guilty, and sometimes you might enter a plea of no contest, which basically is sort of a de facto admission of guilt, but basically saying I recognize that there's enough evidence to convict me regardless of whether or not I'm guilty. Now, it's really important for everyone to understand that the vast majority of people that are charged with federal crimes end up pleading guilty before a trial ever happens, and that's because if the federal government is charging you with a crime, they probably have enough evidence to convict you. So the vast majority of people will plead guilty and enter some kind of bargain in exchange for their guilty plea. They would receive a lesser sentence. There are two graphs here, one on the top right and one on the bottom right, that demonstrate this phenomenon. It's worth taking a second to look at this and understand, again, the vast majority of cases never go to trial. Those that do almost always end up in conviction. So the conviction rate over time, you can see from 1981 to 2020, the conviction rate is up to 99.8%. So if you were charged with a federal crime, there's a very good chance you're going to jail. So if an individual charged with a felony does not plea bargain out and it goes to trial, there are two different kinds of trials, a jury trial and a bench trial. The bench trial is a trial where the judge hears all the evidence and then makes the ruling. A jury trial is when civilians are chosen by both the prosecution and defense lawyers, and they ultimately would decide whether or not there's guilt or innocence. So the prosecution would present their evidence first, and then the defense would go after the prosecution. And then, of course, several different verdicts that could be reached by the jury or the judge in the case of a bench trial: guilty, not guilty. There could be a plea bargain that would end the trial prematurely. There's also something called nullification by jury, and basically what this means is that the jury says that they know that you're guilty of a crime, but they fundamentally disagree with the premise of the law to begin with, and so basically throw out the conviction. That almost never happens. A mistrial is something that does happen somewhat frequently, and mistrial basically means that there's been some kind of problem in the trial, most likely a result of a hung jury, which means the jury could not come to some kind of agreement about guilt or innocence. And in that case, the prosecution could decide to start the trial all over again, or simply just let it go and to let the defendant go free. And in the case of a guilty or not guilty verdict, it is possible for the judge to set that verdict aside if there's an overwhelming preponderance of evidence that the crime was or was not committed by the defendant. But again, that almost never happens. Okay, so hopefully you know a little bit about the trial process now, and please bring any questions to class.